Can a government discriminate against you just by saying nothing? It's a tricky question, right? But it was at the very heart of a landmark Canadian legal case that honestly changed the country forever. So today, we're going to break down Vriend versus Alberta, a case where a law's silence was actually found to be a shout of discrimination.
I mean, think about it. It really gets to the core of what a government is supposed to do for its citizens. Is it enough to just not pass bad laws? Or does a government have a duty, an active duty, to step in and protect people? This exact question, believe it or not, made its way all the way to Canada's Supreme Court.
To really get how this big, abstract legal question blew up into a national debate, we have to start with one person. His name was Delwin Vriend. He was a respected college instructor in Alberta, and his story is such a powerful reminder that behind every huge court case, there's a real person just fighting for their rights.
Now, Delwin Vriend wasn't just some average employee. By all accounts, he was a fantastic one. He was getting glowing reviews, promotions, everything was pointing to a long, successful career. But in 1991, everything just stopped. He was honest about who he was, that he was gay, and his employer's response was swift and, frankly, brutal. He was fired.
Can you just imagine that for a second, being fired for who you are? And then, when you go to get help, you're told that the very law that's supposed to protect you from this kind of discrimination just doesn't apply to you. That was the shocking reality Delwin Vriend was suddenly facing. He had no legal remedy, no protection.
And this wasn't just a Delwin Vriend problem. Oh no, this was a problem for every gay and lesbian person in the entire province of Alberta. And it all came down to the province's human rights law. The issue wasn't what the law said, it was what it didn't say.
Okay, take a look at this. This is the list of things you couldn't be discriminated against for under Alberta's Human Rights Act at the time. You see race, religion, gender, all the usual suspects are there. But notice what's missing. Sexual orientation. It was just gone. It's like in the eyes of the law, gay and lesbian people didn't even exist.
So what was the government's excuse? Their argument was basically, hey, we didn't actively discriminate against anyone, we just chose not to protect this particular group. They actually called it neutral silence. But for people like Delwin Vriend, that silence was anything but neutral. It sent a loud and clear message. Your rights don't matter.
So for 7 long years, Delwin Vriend fought. He fought his case up through the court system all the way to the very top. And finally, in 1998, the Supreme Court of Canada agreed to hear his case. The whole country was watching. Was the court going to side with the government's neutral silence, or was it going to stand up for a community that had been left out in the cold? And the Supreme Court's decision? It was a total slam dunk. In a unanimous ruling, the judges said that by leaving out sexual orientation, Alberta was sending a message that it's okay to discriminate, and that, they said, was a direct violation of Section 15 of the Charter, the part of the Constitution that guarantees everyone equal protection under the law. The violation was real, it couldn't be justified, and they said it had to be fixed.
And this right here, this was the absolute game changer. The court was saying that governments can't just throw their hands up and ignore a problem. If you see a group of people being harmed and you do nothing, that's not being neutral, that's being complicit. Your failure to act is in itself an action. So, the court had a big choice to make. They could have just struck down the entire Human Rights Act, which, would have left everybody in Alberta vulnerable. Or they could find a way to fix the law without totally destroying it. They chose option B. And the way they did it was both really clever and, to some, pretty controversial.
They used a legal tool called reading in, and it's basically what it sounds like. The court takes a law that's broken, and instead of throwing it out, they just add the missing words to make it constitutional. It's like a judicial find and replace, a way of fixing the law without having to start over from scratch.
Here's a great way to think about it. Imagine Alberta's Human Rights Act was like a workplace safety manual, and that manual protected every single employee, except for the people who work the night shift. The Supreme Court didn't throw out the whole manual. They just took out a pen and basically wrote in the margins, "Oh, and the night shift too." That's what they did here, adding sexual orientation right into the law.
Now, it's worth noting, not everyone on the court was on board with how they did this. One of the justices, John Major, he agreed the law was discriminatory, for sure, but he didn't think it was the court's job to rewrite it. He argued that by adding words to a law, the court was acting like a government, not a court. He thought they should have just sent it back to the politicians and said, "You fix it." So the Supreme Court had spoken. Case closed, right? Well, not even close. The court's decision was really just the beginning of a whole new chapter.
The ruling lit a political firestorm in Alberta, and the shockwaves were felt all across the country for years to come.
The reaction was just explosive. On one side, you had social conservatives who were completely outraged. They were demanding the government use something called the notwithstanding clause. It's this constitutional escape hatch that lets a government ignore a court ruling. On the other side, LGBTQ+ activists were celebrating, but they were also facing a terrifying backlash, including death threats. For many of them, this was Alberta's Stonewall, a moment where they finally stood up and refused to be ignored.
And in the middle of all this chaos, all eyes were on one person, Alberta's Premier, Ralph Klein. He was a conservative, his supporters were conservatives, and the pressure on him to use that notwithstanding clause was immense. But then, in a move that I think shocked a lot of people, he refused. He stood up and said point blank that discrimination is morally wrong. For the LGBTQ+ community, that was a huge moment of validation.
The Vriend case really was a tipping point. It was the first domino in a chain that would lead to a flood of progress. By saying that sexual orientation was protected by the Charter, the Supreme Court basically laid the legal foundation for all the victories that came after, including the big one, the right to marry, which came just 7 years later.
So what's the bottom line? The Vriend case was a massive wake-up call for the entire country. It was this powerful reminder that equality isn't something you can just take for granted. You have to fight for it. It was a victory for Delwin Vriend, of course, but it was also a victory for everyone who believes that society should be more just and more inclusive.
And in the end, this whole story forces us to ask a really fundamental question. When a law is silent on a major issue, who gets to have the final word? Is it the politicians we elect to write the laws, or is it the judges we appoint to interpret them? And what's supposed to happen when those two groups completely disagree? There's no simple answer, but it's a question every democracy has to wrestle with. What do you think?